I think, in my view, in my experience, at an early stage business, it's better to look at it as an advisory board to start off with. And the difference between an advisory board and a formal board, effectively you can fire your advisory board at will. They're there to advise you. You don't necessarily have to or need to take their advice. Whereas a formal board of directors, those directors are putting themselves on the public record to say, I am formally associated with this company. They have a fiduciary duty to act in the interests of all of the shareholders. And in a lot of early stage companies, it's difficult to get people to sit as a formal director. I actually prefer and advise young companies to get an advisory board in place to start off with, almost as a test before you put your formal board in place. It might take you 2 or 3 advisors who come and go to actually get the right team in place to move to a formal board. And I think you'll find a lot of prospective directors would like that approach too. As to who comprises the best sort of board of advisors, I think specific industry knowledge is absolutely key. I think financial acumen is important, and I think more and more so sales and marketing, social media, expertise is extremely important.
It's a bundle of rights with intellectual property. So I have in my hand here a mouse, and I also have a Canon lens cover. So if you look here closely, the brand is Lenovo and Canon, and we've got a specific design, if you like, of mouse, and it's a round lens cover. But this particular lens cover, when you turn it around, has a pinching means which means that it opens and closes, and so it's very easy to release the shutter. If you see there, the shutter means. And so here you would have the design, the overall design protected, you'd have the brand name Canon protected, and you'd probably have the mechanism that allows you to open and shut the lens cover as a patent. So the patent refers more to the actual working of the invention or the product, and the design is more the novel features relating to the shape or the pattern, if you like, of the article. And the brand, when you've got Canon or Lenovo, that's the distinctive name by which the actual product is known. And so with trademarks, you can register these and they remain in perpetuity. You renew them every 10 years. There are trademarks that have been on the register of trademarks in New Zealand for over 100 years. I think the oldest New Zealand one is the Edmonds Shorter Rise baking powder. Patents on the other hand, are granting a monopoly right, and the patent will last 20 years. And after the 20 years expires, you no longer have exclusivity. So you hear a lot about generic drugs, as an example. So a pharmaceutical manufacturer will spend many, many years doing R&D to come up with a particular drug, be it Viagra, be it one of the anti-inflammatory type drugs that was around. These drugs, before they even get on the market, after the R&D, they still need FDA approval. So they sometimes only have about 3 or 4 years of marketability exclusively. And after that 20 years is finished, then it becomes open for anyone to manufacture that without infringing the patent. And so that's what it means by generic drugs. So they take the earlier patented product, and after those 20 years expire, they can then put those out on the market. So the whole thing encourages more and more innovation. So you can't have something forever. They're taking the improvement that they've added to it, and they use the existing, what they call prior art, of what's known out there in the marketplace, and they add their part to it. And then someone else will take that, and they'll add to it, and so on and so on. So the monopoly is given for 20 years, and then it's open to anyone else to use that, and that's the whole purpose of it. In New Zealand, copyright attaches automatically. As soon as you create drawings for a three-dimensional object or artistic or literary works, then Once that is created and it's yours, you have a date, that is automatic. It's not a statutory right. It's not something that you can like have a registration certificate for. Other countries allow you to register copyright. In New Zealand, you don't register copyright. So it attaches automatically to any literary, artistic, musical work or to the two-dimensional drawings relating to it. You can patent the idea. You can't have copyright in an idea, but if the idea is workable, so if you've got an idea as to how to improve on the toilet flushing system, you can work that out. You can do it technically. You don't have to have the actual finished product. So you can actually come up with a solution which is capable of being patented. An NDA or non-disclosure agreement is pretty important there. The important thing to remember with patents and designs, registered designs and patents, is that you cannot disclose your invention or your design to the public before obtaining patent or design protection. So you have to file a patent application beforehand disclosing the invention and how it can work or how it actually does work. But if you show it to somebody without confidentiality, then you will destroy the novelty in that patent. You can still obtain a registered patent, but at the end of the day, when you come to enforce it, if somebody says, hey, you registered that patent on the 5th of July 2016, we have evidence here online that you had disclosed it or sold it publicly or offered it for sale on the 4th of April 2016. Therefore, that disclosure invalidates any potential patents you can obtain. Generally, in business, especially in New Zealand or Australia, people are quite happy to sign NDAs. Software itself is not capable of being patented unless it is with a piece of hardware. So, for example, in Fisher & Paykel appliances, smart washing machines, you can have the software there, and how it interacts with the hardware is how you'd obtain the patent. But protecting the software by itself is no longer possible. You have what they call patent trolls, who go about searching for patents that may not have even been, commercialized, but are there on record, and that someone has inadvertently, for example, infringed that patent and don't even know that because they're not even aware of the patent. The patentee, the rights holder, hasn't threatened any action because they're not even aware that these guys are doing it. They've kind of shelved their patent, but it still is valid and it still could be infringed. Now, as an example, BlackBerry, Research in Motion in Canada, BlackBerry, it was basically the downfall of BlackBerry was a patent troll who found a patent in the name of an obscure company in the USA, which somehow BlackBerry infringed. You have to search to see that it's novel, and if it's novel, then it could be patentable. The other thing you have to search for is, do you have the freedom to operate? By freedom to operate, that means what you are proposing, does someone else have it patented around the world? And if they do, then you could infringe. And so searching is really, really important in that case. The Kiwifruit Marketing Board, as it was then, the New Zealand Kiwifruit Marketing Board, never really understood the need to have a brand, because at that stage, kiwifruit was really only produced in New Zealand on a commercial scale. And then somehow our rootstock went to Chile, it went to China and other parts of the world, and so we started competing. And I think it was the mid-90s, I was asked by Zespri to see if we could come up with a global brand name. So they went to a trademark formation company that gave them a whole list of names. And about number 9 on that list was Zespri. So we started searching, and those first 8 names just all fell off very, very quickly. Zespri was one of these total made-up names. Enza is another one in New Zealand. You could say Fonterra is another very good global brand from New Zealand. But anyway, Zespri, we searched and searched, and we couldn't find anything similar anywhere. And so we came to the conclusion, look, we have the possibility of a global brand here. First of all, we called it a Chinese gooseberry. Then we were told we had to call it a kiwi fruit, and now we have to call it a Zespri. And I remember Paul Holmes interviewing me on the radio. Now we have to call these things a Zespri. I said, no, it's a Zespri branded kiwi fruit. And so Zespri is the brand, it's the distinctive element. Glad Wrap's another one that's become generic. Nugget, I nugget my shoes with Kiwi boot polish. Kiwi boot polish is not the same brand company as Nugget. So yes, it's okay to start with when you're the market leader and the first one out there, first cab off the rank, but importantly, you can lose your trademark if it becomes generic. Yeah, there's a lot of what we call lost in translation. One of the classics was one of my Argentinian friends coming out here to New Zealand and seeing the Mitsubishi Pajero and rolling over with laughter because Pajero, spelt Pajero, is the Argentinian slang for wanker. Yeah, well, all Spanish-speaking countries, Nova means doesn't go. So Nova, Latin word for new, and the Chevy Nova, and they couldn't understand why in Spanish-speaking countries it was meeting with resistance. Nova doesn't go. You can come to us, we're the experts in terms of getting this done for you, but I often help young people and say, hey, look, here's the website, here's what you have to do, go and do it yourself. If you have any problems, come and see me. When you're looking at perhaps developing an export market, you are going to need my help. Because going overseas is a real minefield. For Chinese people, imitation is the best form of flattery. Now they will copy your product and say, look, we love the design so much that it's so nice that we copied it. So, thank you very much for showing us that. So it's a trap for young players. You have to, even when you're starting to think about a possibility of exporting to China, you have to protect it there. It's not an expensive exercise. Even using us, I mean, it's under $2,000 to get your rights protected there. So it's not an expensive exercise. It's all relative, I guess, if you're starting off your business. But the reality is, get it protected over there. Don't do anything. You will lose it otherwise. If you apply to register a trademark on the 1st of December 2016, you would have until the 1st of June 2017 to file in other countries around the world and backdate it to the 1st of December. 2016. So that gives you a breathing space of 6 months, that window, to file in all these other countries that you want to register it in and backdate it to that 1st of December. But what if, before filing in New Zealand on the 1st of December, you've spoken to a couple of people about, look, I want to find a distributor in China, can you help me? Oh, well, I've got my friend there in Shanghai, yeah, I'll put you on to him. You see, contact that person. Odds on, no matter what goodwill is at stake here, that person will register your trademark before you do.
And we're one of the easiest countries in the world to do it. You can do it yourself. I would recommend you get a solicitor to do it. And the standard constitution normally for setting up a company that is pretty much all you need. The real key is if you're doing this with someone else is you've got to get clear with that person or those people about what people's expectations are, what do they want from the business, and how is everyone going to contribute. My experience in having seen a number of businesses blow up in the context of shareholders or directors getting into conflict is that they haven't had those clear adult conversations up front. And a lot of that's around if somebody's putting in capital, are they also being expected to actually put some effort in? If you've got one person who's quite happy to work for very little and the other person needs to pay a mortgage, those sort of things, the money things and the effort things are the things that will come along and bite you. Sometimes not that quickly, but ultimately they come along and bite you. So when you look at the documents that set up a company, the Constitution is generally a relatively standard document unless you're doing something quite unusual. The shareholders agreement is the thing that you want to write up. And the starting point for that is not necessarily to go and see a solicitor. It's actually for you, if you're working with others, to get really, really clear on a page or 2 pages, what are those basic building blocks and what are your expectations of each other and of yourself when you're entering into this. So not just the money, but who's putting the effort in, how long we expect it to take, what happens if somebody wants to leave for whatever reason, what happens if somebody actually gets ill and has to leave. It may well be that you're quite keen to work with some person, but you're not particularly keen for their spouse to end up being your business partner if they get sick or fall over or something tragic happens to them. I would say that's a fairly good indication that at some stage down the track you're actually going to have some real problems.
The 2 important things in the legal piece, and especially if you have a partner, you need to make sure that you have the constitution and you have your partnership agreements and you invest the time at the very beginning to do all of that, because the easiest time to have a hard conversation with a partner or with anybody is when times are good. And you can have those hard conversations and no one gets upset. The last thing you want to be trying to do is have a conversation when you're not happy with each other, and that makes that conversation twice as hard. And they can be your best friend, they can be your brother, your sister, whoever. You still do everything like they're a complete stranger, and it's really easy to have those conversations. And then it's the same with your distribution costs. The distributor is your arm to the market. So if you don't do that piece right, you can have the best product in the world, and if it's not getting to market, it won't fly. You want to just take the legal advice, spend a little bit extra, get it done. And we've all heard of the horror stories of we've been best friends for life, and you've been in business for 20 years and it was great, and then someone gets divorced and a new member of the party comes in and all starts derailing, and the next minute everyone's at war and we didn't sign anything and who's got what, and take the time, have the hard conversations early.
Well, I think that's where New Zealand is a fantastic place to seek mentors. If you make contact with someone, you more than likely will get a response, and that distinguishes us from many other countries. We are a generous culture. We like to help young people, so I think the accessibility of senior business people and potential mentors is a real standout in New Zealand in terms of giving young folks opportunities, and it's important to grasp that and realise that probably no one is beyond your reach in terms of at least having a chat, having a meeting, getting some valuable guidance. When I started my law firm, I knew nobody, so if I'd meet someone at a business function, I would just leave it a week, give them a call, see if they're free to lunch, and pretty much everybody was. And it would just amaze me how few barriers there were to spending some time with someone and trying to persuade them that you had something to offer. I had a client come and see me with quite an early stage business, and they had about 5 or 6 companies. They had an IP company and a manufacturing company and a development company and a distribution company and a sales company, and they'd managed to get different shareholders in each, which was a nightmare. So transferring the products from one company to the other, different shareholders would be advantaged or disadvantaged, and I think investors and experienced business people run a mile from that. So keep it simple. In the early stages, you probably won't get outsiders to be directors because of the risk, but you may well get outsiders to be advisory board members, which is what it is. It's an informal board. In the early days, you may or may not have to pay them, and I think one secret with advisory boards is just keep them fluid. Probably ask people to come on board for a year for a couple of reasons. One is to see how you and they gel. If there isn't that gel, you're probably wasting each other's time. And 2, as a company evolves, you may need different people mentoring you. I think to a large extent in the early days, an advisory board is a way of surrounding yourself with mentors who have some commitment to your business. One common mistake is you're thinking of doing something and you start talking to a friend or two, and quickly enough someone says, well, let's do it together. And feels great, group of friends going off to do something together, much less lonely than doing it on your own. And you better not leave Richard out, because he's been in part of the conversations as well, and Mary's been involved recently, so we better include her. And all of a sudden you've got a group of shareholders that were not really put together from a commercial point of view, but for more of a social reason. So just be a little bit thoughtful about who needs to be a shareholder, who needs to be a director, who needs to be involved, for how long, and what sort of stake in the business they should receive for their involvement. It's not axiomatic that everyone provides equal value. And these things are easy to set up and really hard to dismantle. About 4 or 5 good reasons to have one, but they're standard printed form often. And as you say, the gutsy stuff is usually done in the shareholders' agreement, which is a simpler document. It's also a private document, whereas the Constitution's registered at the Companies Office. I think the key with shareholders' agreements is to make sure it captures the deal between the participants. I've seen a lot of shareholders' agreements that are full of all the lawyer stuff, full of all the boilerplate clauses, but don't actually start with the beginning, which is who's going to be involved, who's responsible for what, and what they're going to get paid for doing that. Because too often, a year or two later, there's some disharmony because those expectations weren't nailed down, and some people are feeling that other people are not pulling their weight or doing what was expected, or someone's making decisions that they thought were their own decisions, which the others feel should have been the subject of consultation. So I do think if you go to a lawyer, if you're not careful, you end up with a 30-page document which is light on the commercial deal and heavy on a lot of mechanics. Having said that, you can download shareholders agreements from the internet, and you'll see there are important provisions which are legal, things like preemptive rights. If one shareholder wants to sell, what's the process to do that? What happens if there's, say, two of you involved 50-50 and you can't agree, the deadlock type provisions. So some of those are more technical and important, but as I say, make sure you start by nailing down the deal. And before you get into a formal shareholders agreement, just get the deal down on 2 pages in plain English. Who's responsible for what? And the other thing with shareholder arrangements is they will evolve. You don't want to spend thousands of dollars on legal fees to produce a shareholders agreement for a startup, because more often than not, within a year or two, it'll need some rethinking again about who's doing what, how things are going to be funded. When the company runs out of money, whose job is it to put money in what share? And so to have a review mechanism, and I think a lot of shareholders agreements don't have that. It's seen as a static document, which doesn't make sense if you think about it, when it's governing a rapidly growing and evolving business that might be doing something quite different in 2 years' time from the original idea. Like learning to play tennis, you can't say, well, I'm going to really focus on my forehand, which might be the product, and I'll come back to everything else later. You won't play a great game. You really have to start building the full range of skills as per the periodic table. And the same applies just in the area of law. You do need to evolve your understanding of employment law, IP law, as you go. You won't be an expert on day one, but you want to make sure that your own knowledge and the advisors you're using, that skill base is evolving as the business evolves. So for example, in the shareholders agreement, it's really important to work out who owns the IP that different people have brought to the business, if that's how it's worked, who owns the IP that's created by the business. There's a famous Cisco case where one of the staff left and created a competing product that they had created at home during their employment with Cisco, and then they were bought out for some huge sum of money a few years later. You don't want to have to go through that. And same with employment law. You need your contracts to cover who owns the IP created by the employees. So even though there's so much to do just to get your product up and running and get it marketed and created, you do need to allocate some resource to these things, so there's a bit of a ratchet effect where the progress you make isn't cancelled out by mistakes or people walking off with the IP. It is. It's a guesstimate, because more likely than not, if those of you involved in the business can't bring it together to monetize it, then it was probably all worth not a lot. And then once it's monetized, obviously everyone will have a strong view about which contribution was worth more. So I think at the beginning it's a rough and ready guesstimate of what the ratio is of what everyone's bringing. And after that, the value should lie in the company and everyone shares in that. I think a key is to try and distinguish who you need to really drive the business, who are the owners, who are the leaders, from those that can offer goods and services. Because those goods and services, the value of those will change over time. And if you've given away shares for some work at the beginning, the value of that may become disproportionate. So I think that's the trick, is to distinguish goods and services you need now from ongoing leadership and drive and skills that will drive the business. You know, the second typically relate to shareholding, and the first more to some other instrument, maybe some options, it may be a small shareholding, it may be a debt that's due in due course. New Zealand doesn't have a great tax regime for options, so when people exercise their options, say for $1 and the shares are worth $3, they'll pay tax on the $2. Whereas the person who has some shares that they bought for $1 and sell for $3, there's no tax. So that's one of the reasons options are a little bit less used than they are in many other countries. You may say, well, what's the point? Because I don't have the funds to sue an infringer, because it's only a license to sue. But if you're looking for an investment, an investor, and you've taken no steps to protect your IP, they're going to say, well, if you don't value it, why should I? Well, it's interesting talking to one of our patent lawyer friends in the States. He says, if you've got development companies here and you're talking to one of my clients, they'll say, oh, look, we're excited, we're having our lawyers draft up a license agreement. He said, we're not, we're actually studying the patent to see if we can carry on without you, see if we can work around the patent. And that's just not the way Kiwis think. We're told that there's a license agreement being drafted, we wait for the license agreement. And so yes, that's patent world is brutal. So employment agreements, not the most fun aspect of running a business, but there are some important things. One is the difference between an employee and a contractor, and it doesn't matter how clear the contract is that it's a contractor agreement with none of the usual protections for an employee. The law comes in on top of that and says, sorry, in certain circumstances, the person's an employee, they do have access to KiwiSaver, they do have protections for being terminated and so on. So you need to understand that and get advice on that. More recently, the 90-day trial period is very helpful for young businesses. It's hard to choose the right people, and it does give a no-fault termination within 90 days. It is a bit technical. You do need to get it right. The other thing with employment agreements is making sure that they're clear that the IP developed by the person while they're working for the company belongs to the company, whether it's developed out of hours, at home, wherever, it belongs to the company if it relates to the job. And a restraint of trades, so that your top employees can't move straight from your company to a competitor. They can at some point. There are limitations on how long that can be. And just the last thing is, a lot of Kiwi businesses try not to spend money on employment agreements, but it's worth spending a bit. You need to know that your employment agreement meets the current law. If it doesn't have the required components, then it can be invalid, which means your restraint of trade and your IP clauses are ineffective. But it doesn't cost a lot to get an employment lawyer to just read through an agreement and say it either is compliant or it isn't. That's like an hour and a half's work. And that's probably a general issue with law, is law is available off the internet, it's available from friends, but to the extent you use lawyers, it's very permissible to say, look, this is my budget, what can you do for that? Or I only want you to look through this to tell me if it's compliant or not and make any changes to make it compliant. I don't want you to go through word for word and improve the drafting. I don't have the budget for that. And these days, that's certainly for an early stage business, the intelligent way to use lawyers is just focus their attention. And have that discussion up front with them. Say to them, what's the minimum you need to do to make this work and what will it cost? Obviously, as a lawyer, I watch people choose lawyers, and you can see it's the wrong lawyer for the job sometimes, because that's the only lawyer person knows. And it's worth a young business starting to get alongside, if it's a business, a commercial lawyer. Maybe you work with a more junior lawyer in the firm, and maybe you can't afford to have the partner supervision and input, but still you've got someone who's in a commercial law environment, who's got experienced lawyers around them, and then they can grow with your business. But so it's worth investing in a relationship so that they're there when you need them. If you zoom around the town, picking here and picking there and getting a bit from someone else, you're not really building a professional relationship, and in due course that'll be valuable. So one of my favourite tools is a heads of agreement. It's basically trying to capture the key aspects of a commercial deal in business language, and they're invaluable in terms of bringing people together and bringing the deal together, and then in due course that can be turned into more formal documents if need be. But in some cases, a good heads of agreement is all you need, at least to get started on a project or a relationship. And with that, it's perfectly valid to have a document in plain commercial English, just setting out what the obligations are for each party, try and predict what may evolve, what may need to change, what needs to be reviewed, and how does the relationship terminate. One of my theories with legal documents generally is that part of the value is the document, but part of the value is the relationship building that comes from negotiating a document. You get to learn how the other person thinks by trying to think through the what-ifs, think through the issues. How shall we handle this problem? What happens if this happens? And it's not uncommon that during that negotiation process, you just form the view that this other person is not for you, or this other company is not for you, in the way they respond. And so treat the negotiation process as a way of getting to know the other party, whether it's an employee, a shareholder, a supplier, customer. So heads of agreement, I think, are very valuable tools. Confidentiality is very clear and very simple. If something is communicated with a clear agreement that's confidential, then it must be kept confidential. In general, I don't think you should spend too much money on NDAs for the reason I've said, that the law is pretty much there. You actually go a long way by just saying this discussion is going to happen, it'll be kept confidential by both parties. And it's very important to have those, extremely important if you're thinking of anything that could be patentable. If you disclose without an NDA, then you can't patent your invention. Leases, that's another area. Traditionally, when businesses go broke, the two things that send the proprietors broke are generally the bank guarantee and the lease guarantee. So a lease can be a big obligation, may not be the biggest thing on the expense list, but it usually has a term which a lot of your other relationships don't have, maybe 2 years, 3 years, 5 years. So be cautious what obligation you take on. Obviously, if it's a retail shop, the lease is vital, the location. If it's a software company, the lease isn't vital at all. And you want to have the minimum possible obligation and try and avoid personal guarantees, or at least keep them as small as you can. I mean, for an early stage business, you should be trying to avoid guarantees, as I say, unless it's a prime bit of real estate. But you can definitely, the things you can do with a guarantee, you can cap it at, say, 3 months rental. You can have it cancel if you assign the lease, so that if you can get someone else to take off the lease, you're let go, assuming the landlord will agree to these things. Or you can put, say, 3 months rental into a trust account as a bond, so that you know exactly where you are. Heads of agreement. So I get brought heads of agreement that have been signed, and I say to the client, tell me, is this binding or not binding? And they say, oh, it's binding. No, it's not. Well, some of it is. And the law can't handle that very well. So it's absolutely vital you have a clause that says this is binding, or it's not binding, or it's not binding except for the confidentiality clause and the exclusivity clause. But you'd be surprised how many heads of agreement are signed where no one's quite sure whether it's binding or not. To make sure you own the things that you buy or develop, which may include software or some technology. It's about relationships with your staff, your shareholders, your bankers, financiers, suppliers, customers, and having those in a professional shape. It's about minimizing risk. Business is risk and reward, so trying to minimize the reward, trying to maximize the trying to minimize the risk and maximize the reward means just trying to see what could go wrong, what could lop you off at the knees unexpectedly. And lastly, it's about compliance. In the end, there are laws around what we do, and some specific to different industries, and there's no option to have a good knowledge of those and comply with those. So I think those are the 4 areas where law is relevant to a new business.